JP, maybe we'll start with you. Talk a little bit about what is available to someone who submits a request and gets that radio silence.
Sure. Well, thanks. It's great to be here and with friends on the panel and colleagues. As Jim mentioned, this is a big problem, and there are certain obstacles that reporters and members of the public face when they submit a CPRA, California Public Records Act request. And one of those primary obstacles is unreasonable delays that come from, or non-responsiveness that comes from the agency. So there's a few things that I thought would be helpful to go through in thinking about this and talking about this. Talking about the law, examples of how these problems come up, and I'm sure they're going to be familiar to some of you. An example of a success story and a good example of how to deal with an intransigent agency that is just not cooperating. Some proposed changes in the law and some practical tips, which may be taking what you asked for in reverse order, but I will get to it, I promise. And thank you for everybody who's here at 8 o'clock in the morning to talk about the law on Saturday. That's impressive. So the law, to start off, the California Constitution was recently amended to give the public at a constitutional level a right of access to government records. Now, unfortunately, that provision in the Constitution has not been interpreted in great detail. So where we are now is often looking back to the California Public Records Act or the CPRA for guidance as to how an agency is supposed to behave in the face of getting a request from reporters or from members of the public. So here's what's supposed to happen. Within 10 days, the agency has to determine whether there are responsive records that are and disclosable records, and has to notify the requester of the determination by the agency and what they're going to do about it, and also tell when those records are going to be made available. Now, in unusual circumstances, and the unusual circumstances are defined in the law, the agency can give itself another 14 days to respond. So we're talking about a total of 24 days to respond. Still, though, they need to explain the reasons for the delay, and ultimately they're supposed to explain whether they're going to disclose the records or whether they're going to withhold the records. One case out there suggests that the records themselves must be produced within this time frame, but there are other cases that go the other way. And if you read the statute, it seems like that one case that says that the records themselves have to be disclosed within that time frame is probably not exactly on point. Federal courts, this is just an aside, federal courts examining the Freedom of Information Act, which is the federal analog to the California Public Records Act, do have language in their decisions that suggests that the deadline is the deadline for production itself. Okay, but coming back to the California Public Records Act, state law, and what we're looking at. The law also requires the agency to do several things. It requires the agency to produce the responsive non-exempt records promptly. And the California Supreme Court has recognized that this has to mean something because, as the court said in the Powers case, timeliness of disclosure often is of crucial importance. Of course, all of you as reporters understand this. You know that very often if you don't get the records within a specific period of time, it may possibly be meaningless because too much time has passed and it's no longer hot news. The law also requires that the agency not delay or obstruct the inspection or copying of records. So the agency is not supposed to stand in the way, and the agency is actually supposed to affirmatively assist the requester in identifying the records and information and the location of the records and overcoming any practical basis for denying access. So in other words, the government is supposed to help you, right? That's actually in the law. They're not supposed to be non-responsive. They're not supposed to play games and obstruct. But, as I'm sure you've all experienced, that's often what happens. So the examples of the problems are unreasonable delays, where the agency fails to respond to the request at all. The agency fails to respond within the 10 days or within the extra 14 days that it can allot itself. The agency fails to produce the documents promptly. The agency fails to produce the documents at all. Now, these are just some examples, but there's other types of problems where they might assert specious exemptions. There are legitimate exemptions to the CPRA, but often those are abused and miscategorized by the agencies. Or they'll fail to identify records or overcome the practical problems that they're supposed to help the requester overcome. They often withhold all requested records just because some are exempt. This is something that I've seen happen many times, where there'll be a specific universe of records asked for. Some may be legitimately exempt, or there may be some question about it, but in response, the agency just says, well, we're not going to give you anything, or they say that we're not going to give you anything on a rolling basis, when they certainly could. Or they try to assess an unauthorized or an unreasonable fee. How many of you have experienced some or all of these problems? That's, I think, unanimous. Yeah, just about. So these are real world examples. Some of the issues when it comes to unreasonable delays, for example, it's difficult because the law doesn't have bright line rules when it comes. It has bright line rules about the 10 days and the 14 days that the agency is supposed to respond and give you information, but there aren't bright line rules in the law as it's written about when the documents or materials are supposed to be produced. And so what happens is you've got language like promptly and assisting and reasonableness. Just last month, the ACLU filed suit against the Los Angeles Police Department alleging systemic violations of the California Public Records Act because of repeated failures to respond within the time frame or to respond at all, in some cases going on 3+ years. And this is something I'm sure is familiar to many of you. In a case that David and I are working on, the Sander case, another case where I was representing Professor Sander. He had not been given any records that he'd been requesting from the UC Regents for years. And this is, not gotten responses in that same period of time. Now, mind you, this is still in the context where they're supposed to get responses out to you within 10 or 14 days, at least telling you what they're going to do. So the ACLU in this case is asking for a court order to not just produce the records, but also a declaration that the LAPD has violated the law, and asking the court to monitor and track the reporting that is being done by the LAPD, so that the LAPD has to establish a new system that is actually compliant with the CPRA. The case is pending. We'll see what happens. It's in the Writs and Receivers Department of the Los Angeles Superior Court, which Jeff can tell you is extremely slow. When we were preparing for this panel, he was mentioning that now matters are being set out for over a year after the filing of a request.
So when you appear in Los Angeles County, there are 3 judges that would likely handle your case if it's a public records case or if it's an open meetings case. And those 3 judges like to say that every single person in my courtroom has priority. So even though the Public Records Act says that hearings are supposed to be scheduled at the earliest possible time, they claim the earliest possible time is a year or year and a half out.
Yeah, it's, and some of that is a function of the courts and the budget constraints and all of that, but some of that is perhaps not a regard for how important these matters can be to all of you. Coming from the court. So another issue that's come up is unreasonable charges that often get levied by the agencies. Another case that Jeff is working on with respect to the LA Sheriff's Department is charged, you can explain, but $6,000 I think it was for.
So we asked for some emails. We wrote a story about the man who was appointed to effectively run the department, to be the chief of staff to the sheriff, and that man had sent a bunch of racist emails while he was the police chief in Burbank, and we had obtained through the Public Records Act emails that showed the racist messages, and the chief of staff then stepped down after we published our story. So we wanted to know how great is the scope of the problem in the sheriff's department. So we asked for emails with certain racist terms among the leadership of the sheriff's department. And instead of providing us with the records, they said, it will cost you $7,000 to obtain the emails. It was $6,981. And they claimed that they could charge to try to retrieve emails, and that they could charge for redactions, even though there's case law in California going back 30 years saying that the public agency is supposed to bear the cost of redactions. And so rather than capitulate and pay the fee, we, as any American has the right to do, we filed a lawsuit. And we are in discovery in that case, trying to get more information about the Sheriff's Department's practices, and trying to figure out if the Sheriff's Department has done this to other people, or if this was a unique one-off where they didn't want to produce the record. And what's interesting about that is when we sent our discovery requests and noticed a deposition, the Sheriff's Department said, there's no discovery in Public Records Act cases. And we said, of course there's discovery in Public Records Act cases. We were just with you, the County of Los Angeles, in another case where we had discovery recently. And what was going on was that the Court of Appeal went and took a writ because there had been no published decision as to whether discovery is allowed in California. But a couple of months ago, the Court of Appeal came out with a decision saying that yes, there is in fact discovery in public records cases. So we will be able to take discovery in those cases. The Court of Appeal did constrain the scope of discovery in public records cases, and so that may pose some hurdles for us going forward, but we'll have to see how good or bad the trial courts interpret the Court of Appeal decision. And what's important, the reason why we want discovery in these cases is we often don't know exactly what the scope of the withheld records are, for instance. And the only way to do that is to get a public official under oath and try to figure out what went on, or sometimes delays can be a major issue. In one of the cases that we'll talk about later that we have for the San Diego Union Tribune, which is another paper that I work with, we were able to find out through discovery that a water agency had delayed disclosure of records for several months in order to enable another agency that didn't want the records to be disclosed to file a lawsuit to try to stop disclosure. So hopefully, for those litigations that we are able to bring across the state, we can use discovery as a tool.
It's a very powerful tool.
Jeff, can I just ask you a quick question about that? As a practical matter, I think agencies use the cost of the records as an obstacle to access. And in your case with the LA Sheriff's Department, did you attempt to try to exercise your right to inspect the record, to identify maybe a narrower set of documents that might at least bring down the cost?
So we did ask to inspect the record because there's a quirk in the section that they were citing to claim that they could charge us all that money doesn't apply if you go inspect the records. And so we said, sure, let's inspect the records, because that's one way. If we don't have to copy all of them, that'll bring down the costs, right? But of course, they said, no, you can't inspect the records. You have to pay the $7,000 or the $6,981. So, there was some gamesmanship there, but definitely one avenue that you want to do is you want to ask to inspect the records if they're trying to charge you a lot of money, because I know of another case in San Bernardino County where the court did allow inspection of the records. And that was how they resolved the issue where it was a school district was trying to charge a huge amount of money to a requester who in that situation was not a news organization, it was just a person who wanted the records, and that person couldn't afford to pay the huge fees that they wanted to charge. So inspection, particularly if costs are tight, is preferable in some circumstances.
So there's another story that folks suggested that we talk about, and I think it's a great example of how persistence and good strategy can yield good results. This relates to the ghost ship fire in Oakland, and as I'm sure you all recall, last December, on December 2nd, there was a tragic fire at the Ghost Ship, which was a warehouse that had basically been converted into an artist collective / concert venue. 36 people died on that Friday night, and then on Monday, December 5th, the East Bay Times made several CPRA requests to the city for records, asking for building records, fire department records, police records. Is anybody from the East Bay Times here, by the way? Great. My partner, Duffy Carolan, who is here, at the same time warned the city that any delays would be considered a denial, and that the newspaper would proceed accordingly. On December 7th, the city released building department records, but did not release fire and police department records. And on December 16th, the city said that it would produce further records, but that wasn't forthcoming. So over the next couple of months, the city was the paper was diligent about following up, but there were no further records forthcoming. And on February 2nd, Duffy sent a letter to the city on behalf of the East Bay Times demanding disclosure within 1 week or else suit would be filed. And on February 8th, hundreds of records from the fire department and the police department were produced, showing that there had been numerous visits and complaints regarding the warehouse and adjoining properties. And then, here's the best part of the story, is on April 10th, the East Bay Times won the Pulitzer Prize for breaking news reporting, and the Pulitzer Prize committee explained in awarding the prize that it was for, quote, relentless coverage of the Ghost Ship fire, which killed 36 people at a warehouse party, and for reporting after the tragedy that exposed the city's failure to take actions that might have prevented it, end quote. So this is, I think, a good example of not just great reporting, but also the persistence and when it's applicable, the legal help that can spur some action as well. So there is a proposed change to the law that's being floated right now in the legislature. It's called AB 1479, and this would allow a court to impose penalties. Right now, there are no penalties. Other states, such as Washington, has penalties for an agency's failure to respond to or failure to comply properly with the Public Records Act. California doesn't really have a mechanism for that. There is a fee-shifting provision, which is powerful, where if a requester is able to prevail on a Public Records Act litigation, the requester is entitled to reasonable attorney's fees and costs. But there's no penalties under California law right now for an agency's failure to properly respond to a Public Records Act request. So this bill proposes that there would be penalties ranging from $1,000 to $5,000 for an agency's improper withholding of a record that was clearly subject to disclosure, for unreasonable delay in producing records, for assessing an unauthorized or unreasonable fee, such as what Jeff was just mentioning, or otherwise not acting in good faith compliance with the law. The bill has unanimously passed the Judiciary Committee, and it's been referred to the Appropriations Committee. There's some debate about whether the fines are actually going to be meaningful. If we're talking about $5,000, if the agency has either some motive to not produce the records, or if the agency would, at least from their perspective, it would cost much more than $5,000 to comply, they may not find or feel that that's such a great penalty that would be a deterrent. from
You have
that.
to understand that these litigations cost hundreds of thousands of dollars to do on both sides. So if the public agency's hiring an outside firm, the taxpayers are spending hundreds of thousands of dollars. So a $5,000 fine may not deter public agencies. However, it is still would be a useful tool for us, because right now, some of the agencies, or I'm sorry, some of the judges in courts will say, there is no remedy for the delays that JP is talking about. That the way the law is written right now, you need to actually have withheld documents. And if you don't have withheld documents, you have no way to compel an agency to act more expeditiously. I've seen it in several courts before. I've seen other courts. We won in the case that Jim's talking about, in the Coliseum case. We won a declaratory relief judgment saying that the Coliseum Commission had violated the Public Records Act by delaying disclosure of records. But in that case, they had delayed disclosure for a year and a half. So it's a pretty extreme delay. And we also, there's language in a case that we'll talk about in a bit called the Marking case, saying that even a 40-day delay in disclosure of public records is potentially a violation of the Public Records Act. So there's kind of back and forth, but some of the judges say that there is no enforcement mechanism for delay. And so if this bill became law, you could then say, under this provision, I am allowed to say that the agency acted in bad faith by delaying, and therefore I'm entitled to a penalty under the law, and you'd be able to bring that lawsuit. There would be no question.
But it's important to note that the only way under that bill to get the penalty enforced would be to actually bring litigation, right? I mean,
Yeah.
that seems obvious, but that's a major step for any publication to take, to just bring a case. And, given the costs that can ensue from that, it's debatable in my mind whether a $5,000 penalty is, worth it in a monetary sense. But I think at least in the sense that there would be law that you could cite to a judge, or you could cite in a letter to an agency saying, if you delay, you're going to be penalized. I think it would be immensely helpful. But it's just, important to note, there's no way to get those penalties enforced unless you bring a lawsuit. And the number of times that you're able to bring a lawsuit on a CPRA request is minimal.
So Nikki, what do you think about the prospects of this legislation? You're handling the bill in the legislative process right now. What do you think?
So the bill is on the appropriations suspense calendar, which means that any bill that's assessed to cost the state over $150,000 goes on this calendar, and on May 26th, they'll announce the bills that are making it off of the suspense calendar, and that will continue on through the process. We don't know what the fate of AB 1479 will be on that day. The costs we're arguing are very low for this bill because, firstly, the Public Records Act is already intended to incentivize litigation and to impose these costs on the state. And we don't think that $1,000 to $5,000 is really much of an additional cost. But the opposition is arguing that this is going to spur a number of cases across the state, similar to something like ADA litigation, where people, seek to find violations and then go file lawsuits and get agencies or businesses to settle.
Nuisance lawsuits.
Nuisance lawsuits. So because the CPRA already incentivizes litigation, we don't think that this additional discretionary $5,000 penalty is going to really ratchet up those costs. But the Appropriations Committee is considering that issue, and we'll see whether they determine that they should hold the bill for that reason.
So the bill was heard in the policy committee. What happened there?
In the Judiciary Committee, it received bipartisan support, 11-0. There were many members who, on both sides, have made their own requests or have constituents who have made requests and have struggled to get information from agencies. So there's a lot of sympathy from the legislators on this issue, and generally you know, it's a transparency bill. It should get the support of the legislature, unless they determine that for some reason they don't want to see this move forward.
So
Based
the
on-
stated reason for a suspense file in the Appropriations Committee, which is the Money Committee, is for that committee to gather up all the bills that have some fiscal impact on the state, so they can look at them all at once, and then let out the ones that they think ought to be let out considering the state's overall budget, and not let out the ones that they think will have a big impact on the budget and shouldn't do that. So that's the stated purpose. The real purpose is it's a nice, quiet way to kill a bill in which everybody likes it in a public policy committee hearing, but then people come in and use their work.
And
Without a vote.
So the stated concern is that with the penalties, people will bring like a declaratory relief action just based on the delay? Is that the idea?
That's the opposition's argument, essentially. And with this governor, unfortunately, has some resonance because he has given the perception he's the fiscal steward of the state unless it involves tunnels or a high-speed rail system. But I don't mean to editorialize here, so.
Who's on the appropriations committee that you'd like us to influence?
Lorena Gonzalez Fletcher.
She's the chairwoman, she's the chairwoman of the committee. It's a large committee. And we will be putting information out in the legislative bulletin probably this week to inform all of you who's on the committee, and hopefully we can get some editorial support to at least.
And if the
shame
bill
them.
dies, you know, maybe some comments on the untransparent way that the bill died.
Do we know who's leading the opposition?
It's the League of Cities, the county lobbyists, and the special districts. Who else joined us in support? We have some other public agencies that are supporting the bill.
The ACLU and,
The public maybe they're not on
Yeah.
record as supporting it.
they're not on the record.
Okay.
I think they would be chastised by their brethren. So, JP, can I just go back to one thing for a moment? You talked a little bit about the 10-day period for the agency to make a determination whether exemptions exist. And we've heard several examples of how the agencies have interpreted the law in a way that's created delays. Is there any standard that's in the law that limits an agency's ability to interpret the law in a way that creates obstructions, or is it just sort of the Wild West?
Well, the standards are unfortunately not entirely clear. I mean, you've got, in the law, it does say they need to respond promptly. You do have the California Supreme Court acknowledging that that does mean something, but what does promptly mean when it comes to actually producing the records? And I think one of the things that I keep mentally running into a problem with is how to create a bright line rule here, because you can imagine if somebody were to request millions of records, I think most judges would have some sympathy for a public agency if they said, we just don't have the staff for this, we can't handle it, and so we can't do it in a specific time period. Or you see things where agencies will write back and itemize it and say, this would take this many hours to do, or it would, also seen this before, it would take this many years. And in fact, with people dedicated to looking at your request, it would take years, literally years. Now, whether that's true or not, I'm sure in some circumstances that could be defended. But it comes back to this question of how do you ever have really a bright line rule? If someone were to ask for one document, I just want that one memo, yeah, I think that you'd have a very good argument that, you know, any delay is unreasonable in a context like that. But if someone's asking for some huge volume, then I think that the delay, I don't know if we would all agree is reasonable, but I think a judge would say, well, what do you expect?
Well, also depends on what kind of delay you're talking about. I mean, if you're talking about delay and just responding at all.
Well, that's,
That's-
yeah,
and that
that's true.
happens all the time.
That
You don't
happens all the
even
time.
get a
Or you don't get
response.
any response. And one argument.
That's easy to say if you don't, 10 days to write a letter.
10 days
is
to write a
reasonable.
letter, or 14 days. But sometimes you'll get the response that we have not had an opportunity to assess the volume of records sufficiently to give you a response within the 10 days or the extra 14 days. Because you're asking for so much, we need to look at these records and figure out whether or not exemptions apply. That, I've also seen that happen too. So one argument that I've made, and I've never seen it litigated fully out, I wonder if anybody else in the room has, is that, there are exemptions, there are certainly exemptions to the Public Records Act, and often they're legitimately asserted, often they're not, but they're asserted anyway. One argument that I've made before is to say that if you don't raise your exemptions, at least raise your exemptions within that 10 or ultimately 24-day period if they grant themselves their extension, that you have then waived any exemptions. Because what happens sometimes is you'll get a letter back that says, we're asserting exemptions A, B, and C, and then when you're litigating, all of a sudden it's exemptions A, B, C, D, E, F, and G. And so you say, wait a minute, how did, we need a target to shoot at here, and so how did it grow like that? Has anyone litigated that all the way to the conclusion?
Duffy has the one good case on that, right?
Yeah, it's a trial court decision, and I cite it all the time, even though it's improperly cited.
That would be a-
And did you get them to say that this is, I'm shamelessly plugging my partner, who's wonderful and great at this. What, did you get them to say that it was a waiver?
They waived the exemption.
That's great.
That's great.
I didn't know about that.
Yeah.
Well, that would, has anyone ever tried a bill that would, a bill to amend the CPRA that would say that? Yes? Lots of times?
Several.
I think the danger is that you'll then get that 10-day letter that raises every conceivable
Yeah, they just-
exemption
yeah.
rather than one that actually apply.
Oh, and I've seen those letters from the DMV and usually state agencies. They just throw everything in. And then to top it all off, the cherry is 6255, the balancing test, just in case, the 3-page list of exemptions that they previously put down there isn't enough.
Which then makes it impossible to have any kind of an argument with them about whether the exemption actually applies or not.
Right.
They just give you a laundry list, yeah.
Bill?
Would it be possible to tackle this through an amendment to the CPRA that dealt with a presumption of improper delay after a certain point in time? So the burden of proof goes to the public agency to demonstrate that a delay longer than 45 days in producing a record, then the presumption is that they have unreasonably delayed.
I like that idea, although I'd like to think that presumption already exists, because I understand what you're getting at. It would be nice to have more, but, the law already says that they need to act promptly. Law already says that the agency actually needs to affirmatively help you. I mean, how often does that, it doesn't happen often at all, as far as I know, or maybe we don't hear about it because those aren't the ones that result in fights.
I can tell you from the ground up that the Los Angeles Times routinely faces responses to requests in this 6 to 18-month range. So
You mean response of production of documents or any response
getting
whatsoever?
the documents, which is what we want, right? So the response is pretty much meaningless. The 10-day, 14-day thing is not particularly useful from a practitioner's point of view, from the reporter's point of view. It helps us to know exactly maybe the scope of the records or what exemptions they're going to assert, but it's really a very limited utility, and there's great abuses going on up and down the state where you can face. I had another case involving LA County where it was same reporter who was the reporter in the Coliseum case, and they hadn't given him fire department records for more than 2 years. And in that case, they caved after 2 years, and they said, yeah, we should have given you records. But, we're talking about huge delays. Like 45 days would be great in some respects from where we're at right now. And I don't know how it's gotten this bad, but it is becoming to the point where our reporters are using the act less and less and having to go around the act. And I think if you ask Tom Peel at the East Bay paper, he'll say the same thing.
Well, we're letting them get away with it. That's the reason it's working.
Well,
Going to court.
and that's a good segue.
We are in court,
Yeah.
but
But it's expensive, and the remedy that's in the law right now is exclusive to courts. I mean, you have to file a lawsuit in order to enforce your rights when agencies have acted this way. And in fact, they're relying on the fact that many people probably won't go to court just because of the cost prohibition of doing so. So that brings us to our next subject. Is there a different approach that can be taken to create an enforcement mechanism for the act without having to spend a ton of money to do that? Jeff, there are some models in some states that you have papers in, right?
so, and I have mixed feelings about these other systems, but in some other states, they have administrative systems as opposed to just the enforcement being going to court. So, for instance, in Connecticut, there's something called the Freedom of Information Commission. And in Pennsylvania, there's something called the Right to Know Commission. And what these commissions do, they have full-time attorneys, they're arms of the state, and they hear disputes about public records issues in those states. And what's really neat about the Connecticut system is that they come out with a decision, and the decision's persuasive authority, and the agency or the requester can still go to court asking for review of the agency's decision, the FOI Commission's decision. But in Connecticut, the FOI Commission goes to court and defends its decision. So this enables small requesters who don't have the resources to fight in court to still have their viewpoints heard where the FOI Commission has said that records should be disclosed. So, for instance, we have a case resulting from the Newtown shootings where we have asked for the records of the investigation of the Newtown shootings, our paper, the Hartford Current in Connecticut. And the FOI Commission had a great decision saying that we are entitled to these records. It's a unique situation where there's no investigation because the person killed himself and he was acting alone. And so there's no ongoing investigation. Some of you know here that in California, the investigative records exemption never ends, meaning that if these are investigative records, you never get them in California. In most other states, there's a time period for the investigation, and then you can get the records, which is what California's law should be. But in that case, just as an example of how it works, there was a great decision by the FOI Commission. They appealed to the intermediate court in Connecticut, the state agency did. And the FOI Commission, because the Hartford Current doesn't have great resources like the LA Times, so the FOI Commission went to court and defended its decision. Now, in that case, it was so important to us, we showed up as well. So we were represented as well, which is kind of unusual in Connecticut. But we let the FOI Commission be out front in those efforts. And now the case is on to the Connecticut Supreme Court, where, again, the FOI Commission is defending itself before the Connecticut Supreme Court. So the upside of that is that your decision can be defended by attorneys if you in fact win in the administrative forum, or it may be that the agency decides they don't want to go forward with a court dispute, and then it ends in the commission, and you'll spend a lot less money and potentially get the records that you want. The downside is it can take a long time. Right? So Newtown occurred in 2013, and it's 2017, right? So we will probably get a decision from the Connecticut Supreme Court this year, but that's a 4-year process, which is not ideal. And I can tell you, I work in Florida also. We have newspapers in Florida, and in Florida, like, everything happens within 6 months or within 3 months. And that is just an amazing system compared to what we have in other states. But I don't think that California is going to fund the judiciary in such a way that that will happen here. So here's another system where there's more of a downside, which is the Pennsylvania system. So in 2008, Pennsylvania passed a new law because they wanted to help requesters. And under the new law, they set up a right-to-know commission. And the right-to-know commission didn't have the same potential for the attorneys to go defend their decisions in Pennsylvania courts. And so what happens there is you go to the right-to-know commission, and then the agencies can appeal if they lose to the court. And there it's a 3-level system, and you start. So in Connecticut, you start in the appellate court. In Pennsylvania, you start in the trial court. So there you end up having to defend the decision 4 times. Because there's a trial court, there's something called the Commonwealth Court, and then there's the Pennsylvania Supreme Court. And so those are really, really long cases. And I've gone through that process. And literally there in Pennsylvania, there's no fee shifting. Like, fee shifting means everything to public records litigation. Without fee shifting, it is very, very difficult for news organizations individually to have lawsuits. And but we actually assembled a coalition, and we got 19 Pennsylvania news organizations together, and we did a litigation, and it took like 5 years, and we won in the Pennsylvania Supreme Court. But it was kind of a Pyrrhic victory because it was about a snowstorm from 2011, and nobody cared about the snowstorm. But I mean, when you bring these litigations, you're trying to help future requesters. So you do things where you can get changes to policies for future cases. You try to establish that the names of police officers are public in California when they're involved in lethal shootings or just in general. And that's a policy that'll help the reporters going forward. And so we strategically try to take those cases. So it's not the case I mentioned about the $6,900 thing. You know, we could have paid the $6,900 to LA County, but we're trying to establish that you cannot charge requesters for redactions, because if you can charge people to redact emails, that's going to be a lot of money that we can't afford for future requests, because everyone here is probably asking public agencies for emails if you're involved in news gathering. So there are these other administrative systems we may want to consider in light of the financial difficulties faced by news organizations in California, an administrative system that would at least be able to resolve some disputes without the resort to expensive litigation.
So Jeff, the value here then is not only the precedential authority that is created, but the idea that it can be cited by future adversaries, if you will, going forward. That's similar to case law, but a much less expensive methodology of doing that.
Yes, so it would just be the way it works in the administrative commissions. you have your request is denied. You write like a letter to the commission, and almost always it is done by reporters, not by lawyers. It can be done by lawyers, or it could be done just by a regular civilian, right? Because our public records laws apply much more broadly than just the news media. But as a practical matter, a lot of times it's the reporters writing it, and they familiarize themselves with the law. If they're lucky enough, they'll have somebody advising them. And then the agency has, in Connecticut, they can have live hearings where they take testimony even. There's an officer, and the officer can take sworn testimony in front of the agency like an administrative proceeding. In Pennsylvania, they don't do the testimony thing, they just do it on the papers. And then the officer comes up with a decision. And those are people hired by the state. And actually, I don't know if you all saw that the Pennsylvania Attorney General went down in a big scandal recently. And part of that fight was over the person who was the head of the commission in Pennsylvania got fired and then was reinstalled by a court. So one of the problems, I guess, is that is a political, the way it's done, it's a political agency appointment. So it's subject to the whims of politics, which may be a positive or a negative depending on who's in the State House.
How can Florida do everything so quickly relative to the other states? Florida's not a small state relative to the number of people and all of that. How can Florida get everything done within 6 months and it takes everybody else years?
They fund their courts.
They're funding their courts better, and they have a respect for the public access cases, because I can tell you that when you have a libel case in Florida, it goes on for years. So it really is a commitment that is being followed among the courts to give it precedence. The other big difference is there's a court precedent, a court case saying, similar to Powers v. City of Richmond, what JP read to you before about how timeliness is so important in news gathering. But in their case, it was more explicit than Powers v. City of Richmond, and that case is a big hammer to get things through the process quickly. Tom?
So Jim, help with memory here, but CNPA put 3 bills that would have created an office within the Attorney General's Department of Justice that would have been an ombudsman type situation on 2 different governors' desks, one Democrat, one Republican, and in each case the governor vetoed those bills. But several states have gone away from the commission idea, which I think has a lot of more procedures and delays built into a more informal ombudsman approach, where a requester can take their request once they are frustrated with the agency's response to somebody who will take a look at it and informally interact with all the parties to try to resolve it quickly. And so that's the bill that we tried to put into policy and failed, and that all happened 10 years ago.
So one of the reasons why we're raising this today is we obviously don't think that Governor Brown would feel any differently than those other governors, but we think that potentially the next governor might be progressive and might be more inclined to either an ombudsman approach or to a commission approach. And I think it's something worth discussing at least. The ombudsman that I know, situation that I know the best, was tried in the Obama administration with federal FOIA. And some people did report that they were able to informally resolve federal FOIA disputes through their ombudsman procedure. But the problem with the ombudsman is it's not binding, at least under federal FOIA. And so that gives it a very limited utility, particularly if you're asking for like defense or FBI records.
That was the case with our bill, would have been persuasive, but not binding. And
Right.
we also thought that the Attorney General had such a respect among the agencies that if they decided a situation in favor of a requester, that most agencies would have respected it. All agencies, we think, would have respected it.
Well, you can see from Attorney General opinions why you might want to put it in there, but I understand that some of the governors had concerns about how the Attorney General's office going to defend the agencies, state agencies' requests.
That's what it goes down to, because ultimately the DOJ and the Attorney General is the governor's lawyer.
Right.
So do you think we would have more success if we made it a separate office outside of the Attorney General?
You know, the reason we didn't do that was money, because we thought that it could have been done mostly with existing resources within the DOJ back in those days, and it will get a bill that goes outside of that, probably would get tied up in the
Appropriations Committee.
quietly built.
Okay. Well, shifting gears here a little bit, one of the other developments in public records law that has created a delay in access to information arises from a right that many Californians hold very dear, the right to privacy. And more and more, we're seeing a development where individuals whose information may be part of a request are given an ability to assert their right to privacy when a Public Records Act request is made for information containing information about them. Jeff has been at the forefront in the emergence of this. And so you want to describe a little bit about, you know, the problem and its scope?
Sure. I do want to just say at the outset that, yes, we're being negative about some of the things, but there were some good developments this year in public access law. The California Supreme Court decided a landmark case saying that officials, when they're communicating about public business on private devices or on Gmail, that they're still subject to disclosure, and that was a really big win for transparency in
Well, I
California.
was saving the good stuff for last.
And we will be talking about that in a bit, but I didn't want you to think that it's all negative. But unfortunately, what I'm about to discuss is a big threat to particularly news publishers around the state, because now when you make your public records request, you can get thrown into a 3 to 4 year court battle just for making that public records request. So you make your request, and if it's about particularly police officers or unions, you may see union attorneys run to court the next day or a few days later, and they're going to say that their constitutional rights are being violated, and please, judge, stop the public agency from disclosing records to the newspaper, to the requester that they have requested. And then once you are in the battle, it's very hard to get out of the battle. And it can be a huge financial commitment. And so these are called reverse public records cases. And they've been going on for 15, 20 years. But they got more credence in 2012 when a court of appeal published a decision called Markin that said that a teacher could bring one of these cases seeking to assert, in that case, his privacy rights about disciplinary records, and that he could go and try to stop a public agency from responding to a public records request. In that case, he actually lost, and the records about the harassment were disclosed, but he had a right to go to court, the court said in Markin. And the court, unfortunately, went beyond that, and in dicta, so it wasn't necessary to the case, but the court had some language saying that we don't think that attorney's fees need to be awarded to the requester, even if the requester wins in that case, because the public agency isn't opposing disclosure, and the public agency therefore shouldn't be held to pay fees, even if the records are ultimately disclosed. And so the theory then being that the public agency could represent the requester's interest, which, as any of you who works in this field knows, the public agencies are very often at odds with the news organizations in terms of access to information. So after this decision came out, there was a succession of cases up and down the state where the mayor of Sacramento, Kevin Johnson, police unions in Southern California, and other third parties, even a public agency, tried to take advantage of this ruling and embroiled requesters in years of litigation. And in one of those cases, which has been going on for 3 years now, there was a report in Pasadena, and the report was an accountability report done by a consultant as to how 2 police officers could have shot and killed an unarmed 17-year-old in Pasadena in a tragic situation of mistaken identity. And Pasadena had previously published similar reports in the past. In another shooting a few years before, they had published an identical kind of report by the same consultant with no problems. But this time, it was after Markin, and they told the officers, we're going to release the report. And the officers went to their union, and the union went to their attorneys, and the attorneys filed one of these reverse public records cases seeking to enjoin disclosure of the report, and they said it violated their privacy rights under these laws that are known as the Pitchess statutes. And they said, you know, the assessment of their performance was protected under the Pitchess statutes, and therefore the whole report should be withheld from the public. And so what happened was the city didn't say, we're going to disclose the report at first. The city just said, you know, we're thinking about doing it. And that's when the union went into court. The Pasadena NAACP showed up and said, this is unfair. The city is supposed to say whether they're going to disclose records or not under the Public Records Act. And so the judge actually agreed and said, you know, you city, you have to take a position. You can't just stand on the sidelines here, and gave the city like a week to decide whether they were going to oppose disclosure and side with the union, or release the records and side with transparency. And either way, they might have been sued. That's the tough dilemma that public agencies face. And so they said, they tried to have it both ways. The city of Pasadena said, okay, well, we'll release the report with redactions. And that led to us, the LA Times, intervening in the case And the trial court had a whole series of hearings, and then eventually decided that about 80% of the report could be released and about 20% of the report would be redacted under the PITCHS statutes. So we decided, okay, we can live with 80% of the report. We're not happy about that. We think that the 20% probably has the key information that we want, but we don't have that much money. We've already spent a lot of money doing this. Let's, fight another day. So what happens? The union decided that they weren't happy with the 80% ruling, and they filed what's called a writ petition in the Court of Appeal. And writ petitions are discretionary in California. So we thought, because it's kind of a factual issue, we didn't think the Court of Appeal would take it up. But sure enough, the Court of Appeal decided to take up the writ and hear it substantively. So then we were forced into another long proceeding in the Court of Appeal. And we won in the Court of Appeal, even though we didn't actually file what's called a cross-writ petition. And the Court of Appeal said, you know what, the trial judge and the city, they have over-redacted these records. And in fact, when you see these records, what they're going to say they're not privacy records about the officers. They're criticizing the Pasadena Police Department for its failure to conduct an adequate investigation. And so eventually we compelled disclosure of these records, and the records showed that the Pasadena Police Department had fallen down in investigating it, according to the consultant, and also that the officers had blatantly violated policy, that one officer went one way and the other officer went the other way, and they shot at each other. And they didn't put the lights on the squad car, and they didn't put the video on so nobody could see the incident, because squad cars have dash cam video. And so there was a significant disclosure of public information through this litigation. So then we went to the fee part of the case, and we were back before the trial judge who had initially withheld these significant facts from the public, or endorsed the withholding of it that was urged by the city and the union. And the judge in that case said that even though the union had lost very badly in both the trial court and the appellate court, and even though we qualified under all the criteria for a fee award, we conferred a significant benefit on the public, there was a necessity for private enforcement. The court said it was not in the interests of justice under a narrow exemption that it made less narrow. And it said that officers' constitutional privacy rights would be chilled if they had to face fee awards. And so therefore, I refuse to grant you fees in this case that you've been litigating for 3 years against the union. And then he said, he gave us about a quarter of our fees, maybe a little less than a quarter, as to the city, because he said that the city had only been wrong about a few redactions. And so we have appealed, or we have brought that ruling to the appellate court, and we are seeking to overturn that ruling in the Court of Appeal. We've filed our opening brief in February, and briefing will take place this year, and we'll probably get a hearing at the end of this year or the beginning of next year.
So Jeff, how does that work, though? I mean, under the Public Records Act, the fee shifting provision is mandatory. The court doesn't have discretion if the requesting party obtains any records that are being sought and has to go to court in order to obtain them. So how did it get to a discretionary stage in your case?
So the Public Records Act, the judge said, and some other cases have also said, doesn't apply to what's known as a reverse Public Records Act case. So when the union beats the requester to the courthouse and files the lawsuit before the requester does, the union then is not in the Public Records Act context. And so what you have to do is you have to get fees under what's known as the Private Attorney General law in California. And under the Private Attorney General law, it's a different standard. You're also supposed to get fees under the Private Attorney General law, we think, in a lot of these cases, but it's not the same. You shall recover all your reasonable attorney's fees and costs where you prevail in the litigation like it is in a public records case. So just to demonstrate, if the LA Times had filed the lawsuit and the union had intervened in the lawsuit, the Public Records Act would have applied. There would have been no discretion. So this is all created by a court in 2012, saying that now, in fact, that law doesn't apply because we're allowing a different process. And under that different process, you can't get fees under 6259 is the name of this code section.
Duffy?
Now that you've scared everyone who never actually wanted to participate in these third-party reverse CPR cases, how does the LA Times decide when it's going to participate, and has it ever decided just to take a back seat and hope that the agency will advocate on its part?
I don't know that we will participate in these litigations going forward if we don't fix this. But we have two litigations right now. One is for the San Diego Union Tribune that I haven't told you about, and one is this case. And there's a third case in Sacramento. And we're litigating these cases vigorously. We hopefully will either get good results in the courts of appeal or we'll get good results in the California Supreme Court. If we don't get those results, it is not financially feasible to go spend hundreds of thousands of dollars on things in which we don't have a financial stake. And that is going to change the way that we participate in litigation in California. And we will not be part of reverse Public Records Act cases. We will let them proceed without us, or we will file our own cases before, I think the lesson right now is you have to get to court as soon as possible and file your public records lawsuit before they file their reverse public records lawsuit. But that's not a good system, and it was not created by the legislature. And the California Supreme Court said in another case that the propriety of these litigations is still up for debate. And so even though there is this one court decision saying that, I don't think the issue is fully fully framed yet.
Yeah. Paul?
Are you aware of any attempts to change the statute in any way?
So we tried to change the statute, Jim, CNPA, we tried to change the statute a few years ago. The union has made clear that they're not going to let the statute be changed because right now the union loves the situation that's going on in the courts. They're making it very financially difficult for us to get records about their members, and they can delay things for years at a time. And so I think we'll have to renew and explore even some sort of unpalatable deal with the unions if we lose all the litigations. But it may come to that, and that would be that the agencies pay for the cost of the litigation where records are disclosed and the union never pays, and the union's allowed to participate and the requester's allowed to participate. We may try to make that deal eventually, but we're not there yet, and we're trying to fix this in the courts.
There was a bill introduced this year that would address the issue, and we asked that they not proceed with the bill while they're looking at this litigation that's in the appellate courts right now.
And the legislation that we introduced several years ago that Jeff is referring to would have made very modest changes to the law. It would have required anyone asserting their privacy rights in a situation where they're going to court for injunctive relief to notify the requester of that at the same time that they filed against the agency who is the defendant in those kinds of proceedings, and also to apply both the substantive and procedural aspects of the Public Records Act, which of course then would have provided for fee shifting if the requester ultimately prevailed in that third action. But as Jeff pointed out, the organized labor was very strong and killed it before we even were able to get a hearing on it. I will note, though, that it's only a matter of time before organized labor is the victim of the same sort of response because they make requests for information all the time.
Well, let me tell you something that has a little bit of a silver lining. So the same judge in the case who really stuck it to the LA Times had a great ruling 3 weeks later for the San Diego Union Tribune in the same situation of a reverse Public Records Act case. Although, in that situation, there was no union. A public agency tried to take it further and said, we're third parties. We have an interest in the records. So the Los Angeles Department of Water and Power, if any of you have seen Chinatown, LADWP, they're, in keeping with their rich history, they ran to court and tried to enjoin the Metropolitan Water District of Southern California from releasing turf rebate records to the San Diego Union Tribune, which was investigating a huge turf rebate program that was part of the drought relief stuff. And they never thought that the Union Tribune would show up in court. But we did. And it was just, it was, I think, 2 or 3 months after our company had bought the Union Tribune. And we showed up and we fought it out, and in the end, the judge agreed with us that there was, in fact, no privacy interests of people who were voluntarily seeking government benefits. And it turned out that the city attorney of Los Angeles was one of those people, Mike Foyer, and he was on all the briefs. He was at the top of every brief. Because they defend LADWP. And so in that case, the same judge said, there is no exception here, and you get all of your fees. And so he awarded $160,000 against LADWP, and there were other water agencies that were involved with LADWP as to these turf rebate records. And LADWP was required to pay most of the award. So LADWP went and they filed for appellate review in this other case. And so they're saying that they're aggrieved and that their privacy rights of their water users that they're trying to assert will be forever chilled if the LADWP has to pay the award for a case where the turf rebate records were disclosed.
One small point, just very quickly, about reverse CPRAs. As bad as they are, and as much as it sort of puts the original requester in a position where he or she shouldn't be put, it's not as if you're going to get involuntarily dragged into court by this procedure. The reason I bring this up is I've gotten questions from a number of reporters. Essentially, are we going to get sued for filing a Public Records Act request. The third party may come in and try to get an order saying those records can't be released, and the requester has the option of joining in that litigation, and that's not a good scenario. You know, you're put to the decision of having to decide whether you want to go into court, but you can't be involuntarily dragged into court just for submitting a Public Records Act request.
Except in Sacramento. The mayor sued the Sacramento News and Review.
As a real party in interest.
But didn't the Markin case say that?
David, unfortunately, the Markin case does say that you can participate if you want to participate if you're the requester. And it didn't say that you're necessarily a real party in interest. And in fact, Judge Chalfant doesn't think that you're a real party in interest. But it says that you have to be given the opportunity to intervene, and you have to be given a meaningful opportunity to intervene in those cases. And that would suggest that you don't directly get sued in those cases. But here's the thing. They're going to decide your request. If your request is really important, you're going to want to show up and fight. But in other states where we don't have a lot of resources, we've had to say, no, we withdraw the request. So, I mean, it can come down to that, which is really embarrassing. I mean, whoever wants to say that?
Right. And the chilling effect that it has on the public's right to know. Well, I am committed to end this on a high note today, after we've completely taken the air out of the room. And it's just fascinating. But I do want to talk a little bit about the Supreme Court case that ruled on the ability of public officials and public employees to use private emails, accounts, and devices for public business. So David, you want to talk a little bit about that case?
Yeah, just briefly, the factual background. A gadfly in San Jose submitted a request for records to the city of San Jose, 32 categories of records, asked for emails that were both on government and on private accounts. The city released records that were on government-owned email accounts or government telephones, text messages, but didn't release any records that were on private email accounts sent by government officials or were on privately owned personal cell phones, text messages. And so they went into court to get those private emails, the requester did, and the original trial court said the city has to disclose records that are sent on private devices or are sent via private email accounts. The city appealed that. The Court of Appeals said you don't have to release records that are sent on private accounts, even if they relate to the public business. If they would otherwise qualify as a public record under the California Public Records Act, you don't have to release them if it's sent on a Gmail account or a Yahoo account or on a private cell phone text account. So that was the Court of Appeal. The California Supreme Court, fortunately, unanimously on March 2nd, reversed the Court of Appeal and said, and I'll just quote it directly, "A city employee's writings about public business are not excluded from the California Public Records Act simply because they've been sent, received, or stored on a personal device." So the practical impact of that is that government agencies can no longer conceal from public view records that they don't want the public to see by just sending them on their Gmail account. I mean, in many ways, this seems logical in a fundamental way. If there's a record that that relates to the public business, that's the definition of a public record under the California Public Records Act, why should a public agency be able to exclude it by just sending it on Gmail rather than their government account? It seems basically logical, but this decision is a huge victory for access, because I think there's a growing number of public officials, public agencies that, just like the rest of us, that are using their private email accounts, sometimes in conjunction with their work account. Sometimes, those things go back and forth. So the ability of records requesters to get at records that they should be able to get at because they relate to the public's business that are on private accounts is now established. as law, a unanimous decision of the California Supreme Court. That's great. There are a couple of aspects of the decision, Smith versus City of San Jose. There are a couple of aspects to that case that I think leave some questions open and could lead to more litigation. One of those is, and I've already gotten several questions from people, well, does this apply to Twitter accounts? Does it apply to Facebook? Does it apply to social media? And I think the answer clearly is yes. I think what the Smith versus City of San Jose decision says is that the medium doesn't matter. The question is the content. If the content relates to the public business, doesn't matter where that content resides. It is subject to disclosure. But I suspect we're going to get agencies that say, well, they didn't, Smith was talking about, email and text messages. They weren't talking about communications over Twitter or on Facebook or, retained in some other way. So that's one area where I think there may be, further litigation. There may need to be better definition in the law. Another aspect of this decision that I think is important is that it tweaks the definition of a public record under the California Public Records Act. Public record versus, what's a private, or what portion of a public record is private. The definition that the Smith versus City of San Jose court addressed, the previous definition as it were, only records that are quote unquote purely personal and totally devoid of reference to government activities are not a public record. And the City of San Jose decision said that definition may sweep too broadly, and so suggested a sort of paring back of what a public record is, and said, so the Smith decision said that in order to be a public record, it must relate in some substantive way to the conduct of the public's business. Some substantive way. I think that injects some uncertainty and ambiguity, unfortunately, in the law into what exactly is a public record that I think could lead to, further litigation, and maybe there needs to be further appellate law that sort of defines that. And I suspect that there are going to be agencies that cling to that new language in the Smith decision and say, well, it's on a private account, and it doesn't relate in some substantive way to the conduct of the public's business. But that's maybe the one aspect of the Smith decision that is, and it's a relatively small one, that's problematic. The overwhelming import of the case is that it opens up a huge realm of media where records are now kept, that is, on private emails and so forth, to access under the Public Records Act.
I have a question for that I think would be an interesting thing for CNPA, which is, would it be useful to have an analog of the federal law that says federal employees have to copy their official email accounts with whatever they've done on a non-official email account about official business? And what would be the prospects for success if we were to have a state kind of law that mimicked the federal law that was passed last year?
Well, I think it would be very helpful. That is one of the aspects of the Smith decision also. And David, I was going to ask you about that. I mean, for a practical matter, how does an agency retrieve that information? I mean, obviously, we're talking about private devices or, private accounts. An agency can't just reach in and grab all this information, right? So how does an agency do that?
So I think one of the issues that the court in Smith had to grapple with, one of the most important issues, was that there are limitations on the government's ability to just delve into a private individual's email accounts. The Fourth Amendment says, of the U.S. Constitution says, it guards against unreasonable searches and seizures. Would the government have to go get a warrant in order to go into the private email accounts of the individual government agents whose records are at issue? The court got around that problem or potential problem by offering a suggested path to get the records. It first said, though, at the outset, the court said that an agency may reasonably assume that its individual employees can get their own records, and it can reasonably assume that the records have been searched for adequately if the employees themselves do it. And it suggested a method by which employees could do that, which has some safeguards to make sure that they're actually doing what they're supposed to do, but arguably not enough. They say that the individual employees whose records are at issue should go in, find responsive records, and then prepare a sworn statement saying that they went in, looked for responsive records, took out what they found, and gave them to their employer. So they swear this under oath. It's only a suggestion in the California Supreme Court decision. It's not, they don't order that process to happen. But I've heard a number of questions already. Well, how do we know that they're actually going to do that? Why should we rely on an individual employee to go into their Gmail? And it's a good question.
So do you think that legislation can?
I think it would be helpful too in the preservation of records because employees come and go and they take their devices with them.
Tom?
And
Jim and Nikki and I were able to participate in a webinar that was sponsored by both Williams and Sorensen, which is a huge municipal law firm. And
Oh, we're done.
in that session, the legislation that you described appears to be a best practice that city attorneys are recommending for their clients. And so I think that legislation might actually be supported by both sides of the equation. Just one other point here. It seems clear that the two largest public policy issues for the newspaper industry associated with freedom of information are delay and the reverse balancing test problem.
Reverse CPRA.
Only bend on these issues based upon pressure. And the newspaper industry hasn't really attempted to put that kind of pressure other than through litigation or individually. So what Nikki and Jim and I have talked about is to create a broad coalition, both of the newspaper industry and every other requester and interest group that we can find that routinely uses the Public Records Act, like we did with the Brown Act reform back in the early 90s, and then create a concerted effort that will not only build the data and the evidence, but put some pressure on both the legislature and the executive. And I think that CNPA, in fact, would be the natural leaders of that coalition, but it could be made very broadly. And so we've been talking about this, and that's the only way we're going to get this project done, in my opinion.
Well, I know we're running out of time. I'd like to open it up to the audience for at least a couple of questions, since we have such a distinguished panel of experts. Does anybody have anything that they want to bring up that either we've talked about or maybe that we haven't covered yet? Yes.
Yeah, this question is for Mr. Glasser. One thing that we run up against a lot, and I'm sure as soon as I say it, everybody's going to chuckle a little bit, but that's personnel issues and how those are defined. Sometimes we will submit a request, and even if it's something that's tangential as, like I said, performance reports or anything like that, it just seems to be a very a scapegoat, if you will. Can you kind of touch on a little bit of the things that, or tips that you have in going around that?
Well, so the personnel exemption is, again, employees have certain privacy rights in their personnel file. And, as a practical matter, you're not going to get around it unless there's some discipline. So if it's a non-police officer, you are entitled to records that are personnel records that are disciplinary records that show the basis for the discipline, the history of what happened, and what discipline was imposed. And that's where, and the standard is where discipline was imposed or where the allegations were well-founded. So because in the Marking case, because the teacher was reprimanded for sexual harassment, discipline was imposed, and so therefore the Court of Appeals said the records reflecting all of the So I would, it's often those situations that are newsworthy anyway. And so I would go, try to use the Public Records Act in those situations for non-peace officers. Peace officers, you can't get their disciplinary.
Thank you.
Anyone else?
What about
Eric?
education? Isn't there the same kind of really broad interpretation of the right to privacy for administrators at state colleges or state universities that they then throw out as kind of a blanket reason to deny?
FERPA is definitely abused. So FERPA is the Federal Educational Privacy Law, and it's often invoked as to student records. And what comes up there a lot of times is, are they really student records? If it's some sort of extracurricular record, is it a record of student performance subject to FERPA or subject to state equivalents of FERPA?
But that doesn't extend to administrators or any employees, does it?
It would be redacting whatever's about the children within those records, but it wouldn't necessarily mean that you would entirely withhold the records.
Okay. Well, we need to set up for the next panel. Thank you very much for coming this morning, and thank you to the panelists for great discussion.